A brief sort of introduction to statutory construction and some of the canons that are used by attorneys, bill drafters, and of course, judges to determine how bills or laws should be interpreted. And this isn't exhaustive, but there certainly are a few general principles of statutory construction and those canons that are helpful to be aware of. We generally begin with the primary step in interpreting any statute, which is that where the language of a statute is generally viewed as plain or unambiguous, then the courts try to give effect to the statute as written without the need to engage in any sort of statutory construction. And again, it's to give effect to the words that the legislature used. And so we don't want to delve into consulting extrinsic evidence or other things or trying to ascertain intent when the language of the statute is unambiguous. So we should give it its, usual and ordinary meaning. The other thing is, after starting with that, of course, where the language is ambiguous, then the courts generally look to these canons of statutory construction or other rules of statutory interpretation to consider the appropriate interpretation that should be given. So the first finding, of course, is that there is ambiguity in the statutory language. And so basically, most courts say that a statute is ambiguous where the language is capable of more than one reasonable meaning or construction. In other words, can reasonable minds differ? Is there some sort of uncertainty in the language? And just because somebody can come up with more than one interpretation doesn't necessarily make the statute ambiguous. Just because you can figure out a different interpretation. Otherwise, we would arguably find that all statutes are, somehow ambiguous. And so the emphasis that the courts usually use is whether or not a reasonable construction of the statute can result in more than one, meaning to the language. And then you get into, okay, well, now we have to figure out what did the legislature intend? And the basic rule of statutory construction is trying to determine legislative intent by not only the words of the statute, but perhaps the public policy behind it, the legislative history. And so now the courts will go into a range of different factors to determine the possible meaning to assign to this otherwise ambiguous statute. And of course, their ultimate goal or objective is to determine the intent of the legislature in order to ascribe that intent to the legislature as a whole, which is why they often ignore the comments of, say, the author. I'm not sure I agree with that, but that's what the courts generally do. And instead, they just do them, those that are ascribed to the entire legislature, if you will. Those are the ones that are given greater legislative intent. In addition, the history of the statute can often be a very good guide of statutory construction. So here the, courts look at basically the evolution of a statute. How was it amended? For example, did it start by saying one thing is introduced or an early version, and by the end of the legislative process, it said, something entirely different? And so looking at the language and how it evolved is very important. Sometimes the bills contain codified or uncodified statements of legislative intent or findings and declarations that might assist the courts in informing their ultimate construction of a statute and ascribing legislative intent to the enactment of that statute. So you might, again, look at the history of it. And of course, there are a number of extrinsic aids that help interpret these ambiguous statutes. Beyond the text of it or the title, you might find summaries of the legislation, committee and floor analyses. These types of extrinsic aids are often very helpful to the courts in determining things. Courts sometimes go even beyond the language and beyond those extrinsic aids to consider what sort of societal value was the legislature trying to effectuate by the particular statute. And of course, the courts want to use common sense. So they attempt to give all reasonable or practical interpretations to a statute. You know, what is the plain or usual meaning of the particular words? You know, those specific words should be interpreted the way the average citizen may interpret them. And then we get into, again, what we generally call the canons of statutory construction. And don't forget, the courts try to determine if there are any binding authorities, the higher court. So if you're a trial court judge or an intermediate court of appeal justice, does your state Supreme Court, the high court of the land or of the state, have they already interpreted this statute? Is there some sort of binding authority that's construing that statute? They're going to apply that. That's called stare decisis. A lot of grammatical rules apply in statutory construction. You know, things like where does a particular comma come about, but grammar and sentence structure can often be important aspects of a court's analysis as to the meaning of a particular statute. And because again, those will help in the interpretation or construction of a statute. We have some Latin terms of canons of construction. Adjustus dem generis is where the general rules follow the enumeration of particular classes of persons or things, in which case those general words will be construed to apply only to the things enumerated. So in other words, there's a list of specific items followed by some general words that are available. And so we don't want any of that language to be void or redundant or superfluous. And so it helps them, the courts, consider those items, those specific items that are listed that are followed by some general words. Nociter or nociter socis is that basically meaning a word is known by the company it keeps. And this is contextualizing the language. So in other words, how is this word or this phrase to be interpreted? Where is it found? And so that allows you to look at the surrounding text, the rest of the statutory scheme in which this ambiguity exists, and to utilize the context in which a particular word or phrase is used. The courts also like to say that they don't want their construction of an ambiguous statute to result in some sort of absurd result or otherwise be reasonable, basically, is what they're going after. So if an interpretation of the legislature is not going to result in a reasonable outcome, then they don't want to ascribe that particular absurd result to the statute. So the other thing that courts often talk about is that when they ascribe the so-called ordinary meaning of a statute, they're going to try to give effect to all of the words because they believe that the legislature drafts and utilizes words for a specific purpose, and that statutes don't have superfluous or redundant terms. And therefore, the courts generally try to limit themselves, if you will, from ignoring any words or phrases in a statute when they attempt to reach a reasonable construction. At the same time, they also don't like to insert words or phrases into statutes that aren't there. In other words, they're generally unwilling to add language that the legislature perhaps intentionally left out, or they inadvertently left that language out. So the courts don't want to add in language that they're not finding in the statute in order to ascribe a particular reasonable interpretation. And at the same time, they're also, the courts that is, are generally unwilling to correct errors or fix unanticipated consequences of a statute. So they view that as the power of the legislative branch, and therefore sometimes you find state and federal court opinions that actually tell the legislative branch, or at least suggest to the legislature, the state or federal levels, that they ought to revisit this statute, or they ought to correct the statute, or they ought to clarify the particular statute. Again, viewing it as generally not their role. Another canon based upon a Latin phrase is expressio unius. The full phrase is expressio unius est exclusio alterius, which basically is a Latin phrase meaning where the language specifies certain things, those things exclude all others. In other words, if a statute has a list of specific items, then that's the exclusive list generally. Obviously, when definitions are set forth in a statute, those are to control, if you will, the construction or use of those terms. That's obviously a fundamental rule of statutory construction, that definitions of terms that are included within the framework of a statutory scheme should obviously control or dictate the meaning of those terms in the statute. Now, unfortunately, sometimes not all of the terms used in a statute or a statutory scheme are given definition, but where they are, those should be utilized. And that generally leads us to an assumption that most courts at the state and federal levels utilize, which is that words used in one part of a statute should be having or be ascribed the same meaning in every other place where that phrase or word or term is utilized in a statute or a statutory scheme. We also, in California in particular, but in most other states, certain words like may or should are generally permissive. Shall or must are mandatory. Now in California, almost all of the 29 codes have preliminary or general provisions at the outset of those 29 codes. And usually they say right there in a single sentence, the word shall, it means mandatory, and the word may is permissive. So there's a clear delineation between those two terms. So California statute, to ensure that the act is mandatory, only uses shall, it does not use must. Some states use must, some states use both terms. California only shall. Also on the permissive side, California laws use, those statutes use the word may. Again, some states use should. Some states use both. In California, it's the word may is permissive. You also have some instances, again, in those 29 codes in the preliminary provisions where they say other rules of construction, such as the singular term includes the plural version and vice versa, and the male gender includes the female gender and all of that. Two things, even though California codes have that, the Office of Legislative Counsel is following more modern drafting, which is not to utilize the plural, but the singular. In other words, if you have a statute that says cars running red lights violate the law, does that mean a single car running a red light doesn't violate the law? It requires two or more, which is why we utilize the singular. And California's legislature adopted a joint resolution that requires the Office of Legislative Counsel in this state to use what we call gender neutral drafting. So we don't say policeman, we say police officer. We use chairperson rather than chairman. Now, of course, 155,000 statutes in 29 codes, they are not all gender neutral at this stage. There's lots of his or her, which should be they or their. Instead, use the plural in that instance, or the non-male or female versions. So slowly but surely, the attorneys, the drafting attorneys at the Office of Legislative Counsel are making those changes to California statutes. The courts generally say that legislators are presumed to have knowledge of judicial decisions and existing case law. Sometimes that happens, sometimes it doesn't as a practical effect. But again, the courts ascribe that knowledge to legislators. So that is certainly a rule in construing statutes. If a term was construed by the courts in one way, it's going to have the same court definition unless the legislature changed it by statute. As well, the courts presume that the legislative branch is aware of any previous statutes on the particular topic, on the same subject, of course. Also, the courts generally provide or are provided some guidance from other states in other jurisdictions, obviously, who have adopted similar or the same statutes. So sometimes the courts look to other jurisdictions if they have a same or similar statute. Also, if there's a model or uniform act utilized, then how those other jurisdictions have interpreted those statutes, a court may give the same meaning adopted by that other jurisdiction. Generally, where there's a statutory change to a single word, or certainly throughout a statute, the courts view that as an intent or a desire by the legislative branch to actually change the meaning of a statute, and therefore they're not going to keep the same meaning of a statute when that statute has been modified even in a minor way. Of course, there's a long-held canon that the courts don't want to repeal by implication, where statutes are somehow inconsistent with one another or they can't reconcile them. The courts say they disfavor repeal. And so they attempt to interpret or comport potentially conflicting statutes so that they can give effect to both statutes, so long as there's a reasonable construction. So the general canon is that statutes should be reasonably construed to avoid implied repeal. And the same with violating the Constitution. In other words, statutes should be reasonably construed to avoid a conflict with the with a constitutional provisions. So we want to be able to give full force and effect to a statute and hopefully construct it in a way that won't violate an existing provision of the state or federal constitutions. Now, you can probably figure that where they can't reconcile two statutes or that they're somehow irreconcilable, the courts generally give the later enacted statutes effect over the earlier enacted, meaning the most recent statement by the legislative branch through a statute. So the later enacted one, that's the one that's going to control in these sorts of instances. Similarly, when you have two statutes on the same subject, the general rule of construction by the courts is that the specific is going to control over the general. In other words, the more specific statute is going to control over the general statutes. On retroactivity, i.e., does a statute apply retroactively or in the past? That is, before it was actually enacted into law. The general rule in California in most courts at the federal level is no, unless there's some sort of clear intent by the legislative branch to make that statute retroactive. So they're going to look for a clear statement or statements of the legislature that they intend the bill to be retroactive. It's not something that the courts want to guess at. And even where the legislative branch clearly intends by the language of the statute to apply retroactively, if there's an impairment of contract or an impairment of a vested right protected by the Constitution, for example, the courts generally will not give a statute retroactive effect. Another one of those Latin phrases is in pari materia. That is, the statutes are to be construed in pari materia, and that is taken together. And so if statutes relate to the same subject, then we want to construe them together. In other words, the courts are going to try to look at same or similar statutes, compare them, and try to interpret them reasonably, of course, to bring them into harmony. Okay. And so generally, again, they're looking for harmony. They're trying to give effect to both statutes or all statutes dealing with the same subject matter. So as long as they're not in conflict with each other, ultimately, or certainly with the Constitution, either state or federal, the courts are going to try to give effect to all of those statutes that are related, construe them together, basically, and so that they're harmonious, if you will. Sometimes agency interpretations are helpful to courts. Some courts give a fair amount of deference as long as those agency interpretations aren't in clear conflict with the intent of the legislature. Now, don't forget, the courts make clear that they are the final arbiters. They interpret the statutes, right? The legislature enacts them. The legislative branch, that is, the executive branch enforces them, but the interpretation is the judicial branch. It's a fundamental duty or power. It's their authority to construe or to interpret the language of legislation to tell us what the law is. There are also some interesting principles of statutory construction. For example, we try to strictly construe in favor of the criminal defendant, the criminal laws. We call that the rule of lenity, where we are limiting privileges or rights, especially of individuals. We're going to strictly construe those statutes. You know, the labor laws in California, the workers' compensation statutes in the state, and many others are generally construed in favor of the employee, the worker. Again, similar to the criminal statutes, where we're going to look towards an interpretation that is beneficial to the criminal defendant. So that's a general introduction overview of statutory interpretation or construction principles, both here in California and I think generally applicable in a number of jurisdictions and at the federal level.